Welcome to the sales call role play. We found most potential clients are full of emotion and tend to ramble on. That's okay in the private, confidential intake session after you've been hired and you're looking to get more background information. But the sales call, or free consultation, as we prefer to call it with clients, is too brief for that. So we use more targeted questions. Here's how a concise introduction might sound. Don't bother taking notes, you'll have a script for this as part of your toolkit. Sessions do tend to take longer when both parties are present. The example we're role playing here only has one party. Mike will be acting as mediator, and Alex will be acting as the client.
Greetings, Susan. Thanks for scheduling this meeting. I appreciate the time you're taking to gather information so you can make a fully informed decision. We're here to find out whether my style and services are right for your situation, and also whether your situation and goals are within my skill set. So we can determine whether mediation is the best fit for your goals. So in a sense, we're all vetting one another. And when we've done with this, I will meet with Carlos to ensure that he also is making a fully informed decision. I won't be asking you for a decision during this call. Take the time you need later to think it over. But I'll be able to tell you by the end of the call whether it's a case I can take or whether it's better to refer you elsewhere. I'm going to start by asking a few key questions. You won't have much of a chance to tell your full story today, but don't worry. If we decide to work together, the first step is a private, confidential intake meeting with each of you separately. That's when you'll be able to tell us a lot more about your story. So please bear with the process for today, since we only have 30 minutes in this free session. So I'll ask you to keep your answers brief. So before I begin my questions, are there any initial questions that are top of mind for you?
No, I'm okay. Go ahead.
The mediator will now inquire into the client's situation.
So what can I help you with? What's your goal in potentially working with a mediator?
Well, we've agreed that we're going to separate, and I guess we would like to stay amicable if possible and keep it out of courts. That's the goal.
Oh, okay. Well, that's exactly what mediation is designed to accomplish. The goal of remaining amicable is particularly crucial to keeping separation quick and inexpensive, which doesn't mean it's easy. But tell me about that. How mutual is the decision to separate?
I mean, I was the one who brought it up first. I haven't felt any intimacy since, well, I guess since Carlos Jr. was born, really. Um, it's kind of like we just live parallel lives. I've been bringing it up for years now. And so far, he's really just been in denial that there's any problems.
Okay, so you were the one who told him you were done. So how did that go? Have you been able to communicate about it?
Yeah, it went surprisingly well, actually. We did try therapy for a while, but honestly, between you and me, it was totally hopeless. I think he must have unconsciously or subconsciously known it was coming when I told him that ultimately I wanted a divorce. There wasn't screaming, there wasn't really drama. It was just, tears, quite frankly, on both sides. And then he moved out within a month. And that was about 6 months ago now.
Okay, well, thanks for sharing this, Susan. Must have been an extremely painful time, but it sounds like you've both been handling it really well and keeping conflict away from the kids. Is that right?
Yes, we both agree very much about that. And honestly, he's a great dad, totally committed to the kids. So I'm not really worried about the parenting plan, I think it's called. But I am exceptionally nervous about the finances. He's never been open with me about how much he makes. So there's just a lot of gray area.
Okay, I'm going to ask you to trust the process on that, Susan. Financial disclosures are an absolute must. We'll get into those details along the way, but kids and parenting come first, and best if you not be taking the lead with him on those financial matters. Leave that to us. But let's tell me first, though, about what's your current living arrangement?
So, like I said, Carlos moved out, and then I've basically just been living in our home with the kids.
Okay, so it sounds like you've already begun making some decisions together. You mentioned children. Tell me,
Mhm.
names, ages?
So we've got Carlos Jr. and he's 9 years old, and then Katarina, who is 11. Oh, they're just the best kids. They're just so wonderful. But of course, they're really struggling with their dad's absence. So it's been a hard time for all of us.
Yeah. Is there, have you worked out any sort of a regular parenting schedule?
So we've been trying 7 days on and 7 days off so far. Of course, the 7 days off are pretty hard for me. I miss them a
Oh,
lot.
yeah, bet it's hard time for the kids too,
Yeah.
and a difficult adjustment for everyone. We'll talk a lot more about their needs along the way if we end up working together. I just want you to know that I'm trained as a child protection mediator, so we can arrange to hear their voices as part of the process too, if that helps everyone to reach agreement.
Oh, interesting. Yeah, I would love that. I'm so worried about them. I don't want them to feel like, ping pong balls going back and forth from my house and his.
Yeah, I want to reassure you, there's really no need for any of that to happen. Um, but let's shift over now to some financial questions. You mentioned the home. Is that owned
Hmm.
or rented?
Yeah, so we own it. Well, let's be honest, the bank does. And Carlos has purchased a condo close by the house.
Okay, well, close by. Well, I'm glad to hear that you've kept living arrangements close by. That'll certainly help with the co-parenting. Okay, so you've got properties. It sounds like they're fairly
Yeah.
heavily mortgaged. Is there any other real estate owned?
Actually, yeah, we have also a rental, a property, an income property. It's a condo that we own. It is in Carlos's name though. I don't know if that's going to be an issue, but it's in the same building that he lives right now where he just bought the new condo.
Okay, purchased when you were together or after the date of separation?
No, a few years ago when we were still together.
Okay. And together as in legally married, or are
Yeah.
you common?
Yeah, no, legally married about 15 years.
Okay, then I can't give you details on this, obviously, but at this point in time, but I do want to reassure you that it won't really matter whose name is on titled. Check with your lawyer.
Okay.
But generally, assets acquired during the marriage are equally owned, regardless of whose name they're in.
Okay.
Now, employment, are either of you self-employed?
No, I'm a school teacher, so I'm employed by the school board.
Oh,
Carlos is, I guess, a real estate agent, so technically self-employed, but he does work with, at an agency. I
oh.
don't, yeah, I don't know how that works.
Well, so we've got pensions here and
Mm, yeah,
self-employment. Um,
yeah.
okay, a few final questions on my end. Taxes, they up to date? Did you file last year?
Oh, yeah, sure. So we definitely filed our taxes. Carlos has a corporation, so he does his own stuff with an accountant, and then his corporate accountant does my taxes as well.
Okay, that's good to hear. It really slows things down terribly when those numbers aren't known.
Right.
One last thing regarding involvement with authority, CRA or police, ever
Oh
been
no.
called that kind of conflict?
No, 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 nothing like that. No.
Okay, so then would you feel comfortable negotiating with him on your own behalf? Any fear in that regard?
I wouldn't say fear, no. I mean, I'm certainly have some nerves around it. But I'm no wallflower. I feel good standing up for myself.
Okay. So, speaking of which, standing up for yourself, have you hired a lawyer?
I have not. I thought maybe at the end. I don't know. Do I need one?
Those are decisions that can all be made later or any time
Okay.
along the way. We typically recommend that people at least get some advice from a lawyer, but it's not actually mandatory in law. But I feel ready now to describe the process I can offer,
Okay.
and to help you decide whether or not you would want to move forward. But before I begin with my thoughts, is there anything else you think I should know? Anything I've forgotten to ask about that is on your mind?
I don't think so. I don't know. I mean, this whole process is overwhelming. There might be questions later, but I think right now you've sort of covered most of what I want to say.
Okay, great. Now, please remember, we will have, a private, confidential meeting together. We call it an intake session. If we do end up working together, so that will be a time for you to, give us more of the backstory, since I've been pretty directive in the questions I've been asking today.
Okay.
I'll also be wanting to find out a lot more about your long-term goals and things like that. But I think I'd like to describe what I would be recommending.
Okay.
At this point, the mediator knows this case involves a pension, self-employment, and multiple properties. Each of these adds significant complexity to the financial matters, meaning that unless you're a financial expert yourself, you'll need to work with one to get an accurate NFP and support numbers from which to negotiate. Now we'll enter into the overview of the mediation process.
First, Susan, I want to be clear about my role as a mediator. My job is to facilitate conversations that are focused, orderly, and calm. I think of it as sort of temperature control in the room, so that the two of you can make the decisions. Family law is a no-fault process. It's really important to understand. It's not about judgment of the past, but about finding ways to meet your needs, your family's needs for the future. So the process itself is done entirely on Zoom with me. It makes it much simpler. I also utilize Google Docs to construct a written agreement. So I'll provide you with a template on Google Docs that we will work through together through Zoom calls. Along the way, if needed, I can make additional services available. I mentioned Voice of Child before, but also sometimes coaching along the way if there are communication strategies that you want to ask about or that I feel might be helpful. There are some caveats around that, but we'll get into that later. There are a lot of benefits to a mediation process. Primarily for most people, it's the fact that you're the decision maker, unlike a judge or an arbitrator if you did a more conventional route. And so that puts a responsibility on you, but gives you much more freedom to think outside the box. Compared to doing it with lawyers, the cost is certainly lower. My rates are lower, and lawyers, even ethical ones, do have a tendency to squabble. Their hourly rate is greater than ours, and the timing tends to be faster, partly because it's non-adversarial and therefore takes fewer hours. The confidentiality is a big part of this work. Unlike a court process where everything that happens is on the public record, what happens in mediation stays in mediation and is not admissible in court. It remains totally private. I would say from my point of view, I come from a background as a childcare worker, as a teacher, actually. Biggest advantage to the mediation process from my personal point of view is that the co-parenting relationship between you and Carlos is almost certain to improve by the end of this process, because so much of this process is me helping the two of you to communicate on difficult decisions. It's the exact opposite of what happens in court, where the communication tends to be about defeating one another. In this process, it's about putting you on the same team, or I think I prefer the metaphor of playing in the same band, different melodies maybe. But there's no such thing as a process without risk. The risk is very low, but essentially the worst that would likely be ever able to happen is that you've put time and money into the process and it didn't succeed. In other words, you didn't get a complete agreement. If that was to happen, you don't actually have to go back to square one. You can keep the pieces that you have agreed upon and then just go to arbitration, potentially court, but arbitration would be faster to deal with the problems that have not been resolved. If it is successful, which certainly most of the cases we work with do succeed, then it results in a document that will be legally binding, provided it's been submitted to a family court. It can be challenged later. There's no such thing as a contract that cannot be challenged, but it would be hard to challenge successfully. And it will be even harder to challenge successfully if you've worked with lawyers to sign off at the end and divorce financial experts along the way. Those are choices that can be made later, but certainly it's more bulletproof if you have used other professionals, although some people like to do it less expensively. And in that case, it can be done entirely through mediation with the addition of waiver forms and things like that. The timing is, I realize I'm running through a whole lot of information here. I'll make it available to you in text later, so don't worry about trying to retain all of this. Timing is something that is a big issue for a lot of people, and the more professionals that are involved, the longer it typically takes. So you're kind of balancing the precision of having lawyers and financial experts versus the speed and lower cost of doing it only with a mediator. But either way, a mediator would be involved. At least that's my understanding of what would be best for you and for you to decide. My costs are $220 an hour plus HST. That works out to $248.60 an hour. Probably about half the cost of most lawyers in this city. And in fact, a quarter of the cost when you realize you're actually splitting that. So think of it as $120 an hour each, right, plus HST. I keep a docket in the form of an Excel spreadsheet so that at any point in time, you can know exactly what's left on the retainer, because I do ask for a 10-hour retainer at the beginning of the process.
Okay.
So I've dumped information on you. Any questions before I make some final suggestions of where we could go from here?
Honestly, it was kind of a lot. I feel a bit reassured by what you've said. This is definitely sounds like a process I'm interested in engaging in. But that was a lot of information. I don't even know really where to begin or if I will remember it all tomorrow.
Yeah, and I don't want decisions during a meeting like this. That's not its goal. It is part of my goal to determine whether I would be able to take the case. And I can tell you right now that I absolutely would. You have a non-adversarial intention, and just the calm, the tone of voice and your facial expressions through this meeting have assured me sufficiently that I would be willing. Of course, I need to speak with Carlos and give him a similar opportunity. And but the timing is 100% up to you.
Okay. Okay, well, I mean, I don't want to speak for Carlos, obviously, but I know that he'll be fine with it. He was the one, in fact, that suggested mediation.
That's really good. So then, I wasn't aware that he had already indicated a willingness. So, my point of view, that willingness is there. I think for you to full disclosure, I should let you know that, I've spoken about mediation solo and mediation with professionals. In your case, because of some of the financial information that you've provided to me, I would be strongly recommending that you work with a certified divorce financial analyst. You've
Okay.
got a few highly complex components. The fact that you've got a pension with the board, that there is property ownership, that he has a corporation. Each of these creates levels of complexity. And in order for you to get precision about what your rights and entitlements are, that would certainly be the most precise way.
Okay.
Still not mandatory. Sometimes people decide, well, we don't really care about all the details. We're going to come up with our own settlement and so on. So it could be done without those professionals, but my recommendation would be that you bring in some other people.
Okay.
Okay. And then any other questions for you at this point in time?
I guess really just when can we begin?
Well, after I've met with Carlos, if I feel as positive from that meeting as I have with this one, then I'll send an email inviting you to sign on. And if and when I receive notice that both of you have decided you do want to sign on, then I will forward an invoice for 10 hours of my work.
So should I just have Carlos email you then?
Well, actually, that would be the best.
Okay.
If I haven't heard from him within a few days, then what I'll do is send an email to you that it will send to both of you, that I will ask you to forward to him. I don't like to ask you to divulge his contact information. That's the sort of thing that sometimes people get upset by. So rather than giving me that contact information, please do. Yes, thanks. Ask him to do that. And if I haven't heard from him in 5 or 6 days, then I'll contact you with an email, and the bottom half of that email will be addressed to him, inviting him to schedule a call, and my Calendly information will be there so he can book that.
Oh, I see. So I just pass along that bottom half of the email to him then, if you haven't heard from him. Okay.
Exactly. You'll forward that email to him so that you still haven't provided me with any of his contact information. I don't want you to be at any risk of offending him.
Okay, great. Well, I think I've got it, unless there's something else I need to know. I appreciate the time. I feel a lot more relaxed now moving forward.
Oh, I'm so glad to hear that. And look, it's very likely that there may be other questions that come to mind. You feel free to email me. I'll be happy to respond.
Okay, great. Thank you so much.
Thanks, Susan. Be well.
Okay, take care. Bye now.